SJC-12640, Commonwealth v. Richard Bennefield.
Mr. Graham, good morning.
Thank you, Your Honor. Good morning, and may it please the Court. My name is Robert Graham, and I'm here today on behalf of Richard Bennefield, who is the appellant in this case. The issue raised in this case, I believe, is not particularly complex, but it is, in my view, very fundamental to our system of justice, because we're dealing with a very fundamental right here, the right to trial by jury. We believe
Isn't really the right to be tried by either a full complement of jurors or fewer than that?
Yes, Your Honor. This is a so-called 19B issue where we're dealing with a jury which was made up of 5 people in the district court. It was not a fully constituted jury, we might say. Because we believe that bright-line rules are important when these kinds of issues are raised.
Isn't there kind of a gotcha aspect of this case where there's a colloquy by a conscientious judge and there's no issue about the colloquy, and then
I don't think it's a gotcha issue, Your Honor. I think it's looking at the larger issues here, the larger perspective. I fully understand that the judge did do a colloquy, but I can get to that in the future. I think there are other issues related to the colloquy itself. But I think the fundamental issue for this court is how loose do we want to get? And how much leeway do we want to give people?
Well, I might frame it a different way and suggest that the issue for us is whether a signature on a waiver form is somehow more serious or more conveying of rights than a thorough colloquy.
Well, Your Honor, let me put it this way. In Commonwealth versus Osborne, this court has stated pretty categorically that, and I believe I'm quoting it correctly, that there is a moment of pause and reflection that is incumbent upon somebody when they actually are presented with a piece of paper and asked to sign it. And I think our goal is to give the criminal defendant as much of an opportunity to make sure that what he's doing is meaningful and has been intelligently thought through.
He wanted to go forward. This was his idea to go forward after the death of juror's mother, right?
This
He wanted to go forward with 5.
the Derry case, Your Honor?
He wanted to go forward, right?
Yes, yes. In Bennefield, yes, there was a death involved.
Yeah, and the defendant wanted to go forward.
That is,
After, when there were 5 jurors, you don't have to go forward with 5 jurors. There's a constitutional right not to go forward with 5 jurors.
that is correct, Your Honor.
He decided that he wanted to go forward. Is that right?
Well, that is what the record would suggest. However, the argument that we're making here is that this court's cases have consistently emphasized the need for a waiver to be knowing and intelligent. And whether or not the waiver was knowing and intelligent in this particular case, I think is open to serious question.
Isn't that what the judge found, though, after conducting the colloquy?
He did, Your Honor. He found that the waiver was knowing and intelligent.
Okay.
However, that does not eliminate further inquiry, I think, at this point into the question as to whether or not the waiver was knowing and intelligent.
well, don't we let people plead guilty and waive all rights with an oral colloquy?
Well, Your Honor, when somebody pleads guilty, there is an extensive colloquy to be sure that they understand exactly what they're doing. The court inquires how far they went in school and
Right.
whether they've been drinking and whether or not there's been some drug use and that sort of thing, and whether or not they're in their right mind. But Very briefly, Your Honor, I would like to,
Your argument, not so much a knowing intelligent, but just a strict statutory construction argument, isn't it? Or a strict rule construction? Yours,
I think that there is a, Your Honor, I think that there is a strict construction argument. I also think.
because it's hard to argue that it's not knowing and intelligent, given there was a colloquy, a thorough colloquy. But I get your argument that, hey, 19B requires that it be in writing. You know, everybody goofed up, do this again. Isn't that your argument?
Our argument is that 19B requires a writing, and the larger issue that goes beyond simply that 19B requires a writing is that 19B is there for a reason. And the reason that 19B is there is to enable the criminal defendant to have as many options as possible before a fundamental right is waived.
Well, the right to counsel is a fundamental right, and in Commonwealth versus Papilano, under Rule 8, there was supposed to be a waiver, written waiver. There was no written waiver, and there wasn't a reversal. I mean, right to trial by jury of 6 jurors as opposed to 5 is awfully important. Right to counsel is pretty darn important too, and the written waiver wasn't signed.
It is as well, Your Honor. There are 3. First of all, there are 3 arguments that the Commonwealth makes in its brief that I hope to at least touch upon today. And let me address your concern, Judge Lowy, about the Pamplona issue. First of all, Pamplona was a pre-Commonwealth versus Derry appeals court case. It is not the final word. It has received negative treatment subsequently, and I would point to Commonwealth versus Clemens. And also Commonwealth versus Johnson, which again underscored the importance of a written waiver. That was underscored. But even if we were to conclude that Commonwealth versus Pamplona was controlling here or had something relevant to say, it was kind of an outlier of a case. It was a very unique case. The defendant in the Pamplona case was a very, very savvy, dare I say, probably career criminal. He had been through the system many times before. He had represented himself before. He understood the lingo, and he was very capable of advancing his own cause. Furthermore, he had spent time in prison. He understood the consequences of what he was going to do. Now, you contrast that with the case of Mr. Bennefield, who was a 20-year-old, and this is reflected in the record, in the transcript, pages 99 to 104, bipolar disorder, anxiety, depression, taking a bunch of psych meds, post-traumatic stress disorder. He's 20 years old, but he's still trying to graduate from high school in a special school because he has a cognitive impairment. The judge knew about all these things from the beginning of the trial because the man's mental status was a fundamental issue that was raised, and yet nevertheless, the colloquy went forward, and with regard to that, I would also say that this court's cases, and again, I would cite the Commonwealth versus Leonardi, Commonwealth versus Mullen. There's a
Doesn't that
special.
get back to Justice Cypher's question, though, about how an oral colloquy would probably be more helpful to a person, as you just described, as opposed to having him just sign a form?
Again, Your Honor, it's a cumulative sort of thing.
So you're saying you have to have both, is that it? I mean, as Pavo said.
You have to have both.
So is
yes.
that it? So that,
Well, this court has made it
but I
very.
guess what I don't understand is how they reinforce each other or not.
Well, again, Your Honor, I would argue that it is a cumulative sort of thing, that this court has wanted to protect rights by saying you can't just do it, this is not enough, and this by itself is not enough. Together, we may get closer to protecting somebody's rights. I think that's the key issue.
Now,
But-
the statute with regard to this requires only a stipulation.
Well, again, I would like to address that, Your Honor. That's a very interesting point. I have here the Commonwealth's brief in Commonwealth versus Cherry from 10 years ago. And I'm just going to read a very, very short portion from it. It says here, 10 years ago, the Commonwealth was arguing that the district court bench and bar must be given guidance in the application, if any, of Rule 19B and General Law, Chapter 234A, Section 68. 10 years ago, the Commonwealth was standing here with that question. They went on to say that the requirement of execution of a written waiver is explicit, Mass Arc Crim P 19B. Here, the defendant did not execute a written waiver, the Commonwealth said 10 years ago. This failure means that he waived the opportunity to waive his right to a full jury. A colloquy was conducted, but there was no written waiver. And what did the Commonwealth want? The Commonwealth wanted this court to refer the matter back to the trial court to be retried. The Commonwealth 10 years ago in Derry was making the exact same argument that I am standing here today making.
Wasn't there a not, I'm sorry if you don't remember this, wasn't there a not guilty verdict in Derry?
That's correct.
So there's a not guilty verdict. I mean, do you need a second line? You just go to the double jeopardy clause. It's a not guilty verdict.
Your Honor, in Derry,
Yeah,
it was the Commonwealth,
I understand.
and they were seeking a second bite at the apple in order to gain a conviction.
I understand.
And the court told them, well, I think you got a great argument, but, you know, it's for the benefit of the criminal defendant. It's not for the benefit of the prosecutor who is seeking a second chance at getting a conviction. But the underlying principle makes sense, that there needs to be a written waiver.
I'm confused, though. Isn't this is starting to sound more like an ineffective assistance of counsel case than that's not being argued here, right? I mean, you're saying that the defendant is a 20-year-old with all kinds of mental health issues, and somehow having him do this in writing would make a difference. It sounds like you're really saying the lawyer screwed up here. Is that not what you're saying?
I think it's probably, again, I don't know what the attorneys who represented Mr. Bennefield and what the district attorney knew or didn't know. I don't quite honestly know
The
what the
district
judge
attorney, it's not the district attorney's call. I mean, the district attorney could have brought up that he wanted it in writing, I guess. But, I mean, we don't have an ineffective assistance claim. We weren't there to judge whether those 5 jurors were responding positively to the argument or not. You're really left just with the strict language of 19B, aren't you?
Your Honor, I would again refer this court back to some of this court's own cases where you have underscored, if memory serves me correctly, Commonwealth versus Osborne, Commonwealth versus Chiumi, I believe it's pronounced. This court has made it clear that oftentimes a bright line rule is necessary in order to prevent subsequent disputes, misunderstandings with regard to whether or not a waiver was intelligent and voluntarily made. This court has underscored that before. And we're simply asking this court to not extend it. I mean, I think this court said in Derry the answer to the question that we have before us today. We probably, in my view, shouldn't even be standing here talking about this because I think the court has already resolved this issue in the Derry case.
Would you say there was a stipulation here?
No, Your Honor, and with regard to that issue, if I might, the Commonwealth raises the issue. They make a very seductive statement. They say that when the rules of criminal procedure went into effect in 1979, the statute that governed this issue was repealed, and the statute that now controls it is Chapter 340, excuse me, is the Section 68-1. I don't have it in front of me. But whichever case that is, the Commonwealth is arguing that there was a clear, transition, that one statute was repealed, another one became effective, and this is now the rule. I don't agree with that at all. I think, first of all, the statute is not controlling. But if you look at the history of that statute, you find that that statute in its precursor form was implemented, was enacted In 1977, which is 2 years before the rules of criminal procedure went into effect and the original statute that governed this issue was repealed. And I think it's also important to mention, how was it repealed? It was repealed by an act of the legislature that was designed to conform the general laws to the rules of criminal procedure.
But suppose the statute does apply. Suppose it applies, and it says that you can do it by stipulation. Was there a stipulation here?
I don't think there was anything that happened that lawyers in general would recognize as a stipulation, no. I think the judge made a perfunctory statement that everybody's agreed that this is what we're going to do, but there's no evidence that there was any conversation between the Commonwealth and the defense. The Commonwealth was silent. As a matter of fact, in its own brief in the Derry case 10 years ago, the Commonwealth says a silent presumption of the accuracy of the judge's legal pronouncement is of no import.
I mean, apart from this, I guess, prior inconsistent statement you keep reading to us, don't we have stipulations all the time by lawyers? And we've said when they deal with elements, they should be reduced to writing, but you stipulate it's a public way. I stipulate it's a public way. That happens all the time. So how is this not an agreement? We're going to proceed with 5, you're okay, and there was a colloquy.
That is absolutely correct, Your Honor. Ideally, it would be in writing. It certainly can be
Right,
oral.
and what the best practice is a different story than what is mandated. Right? I mean, obviously, the best practice would be to have it in writing. But the question that Justice Link asked you that you're kind of dancing around is, was there an agreement? Was there a stipulation?
And my answer, so that there's no question about it, my answer is no, because, I mean, in order to have an agreement, presumably there has to be some sort of discussion. On the record, there has to be some sort of back and forth or some sort of something in the record that says, yes, I agree to that, and he agrees to that, and we
That's
stipulate.
the colloquy was. Do you agree to go forward with 5? Yeah, I do.
Well, Your Honor, I would say a colloquy is not the same. A colloquy between a judge and a defendant is not the same as a stipulation between a defense attorney and a prosecutor. They're two separate things.
Okay, thank you.
Thank you.
Mr. Farrader. Before you seduce us, what do we do with Rule 19B?
Good morning, Your Honors. May it please the Court, Assistant District Attorney Timothy Farrader from Middlesex on behalf of the Commonwealth. Your Honors, whether it's clear on the record that the defendant has knowingly, intelligently, and voluntarily waived his right to a full jury by way of a judicial colloquy, there shouldn't be a bright line rule of automatic reversal. If you look at the goals of waiver, they're to ensure that the defendant knows the rights that's being waived. They're to ensure that the waiver is coming from the defendant himself and not from counsel, and to ensure that a record is created of the proceedings adequate to withstand a subsequent challenge. All those things took place in this case. There was a thorough colloquy where the judge explained the defendant's rights, ensured himself that the defendant was of a mind to make that waiver, and then found that the waiver was knowing and voluntarily and intelligently made. In this case, I would ask the court to follow the rule that's been applied to Rule 8 cases, and that's being where there's sufficient other evidence in the record to demonstrate that the waiver is voluntary and intelligent. The fact that there was an error and the fact that Rule 19B wasn't strictly followed shouldn't have the very harsh consequence of automatic reversal where the defendant has shown no prejudice. The defendant never argued in the motion for a new trial or in his brief that the waiver wasn't knowing and intelligently or voluntarily made. It's simply that the form of 19B wasn't followed. And I would suggest that this truly is a form over substance argument. The substance truly comes in the colloquy. I've checked in Marlborough and a few other courts. There is no standard form for 19B about explaining the rights or standardized form to be signed. So it would really just be, I would think it would play out. Someone would get a blank motion form, write one sentence, I agree to go forward, and the defendant would sign it. And I think if the judge had just strictly followed the rule, because there is no SIUMI equivalent for 19B, it would have just been a written waiver. And that would have certainly left us in a worse position than the judge actually put us in by having the full colloquy.
Sometimes, though, we insist on these written waivers. You know, even though they don't seem to provide any additional protections, I'm just, in my head, I'm thinking of Commonwealth versus Hilaire, right, in the immigration context, right? We we require that stuff being in writing no matter what, right? So why can't we interpret 19B just as rigidly as that?
Sure. Well, when I was looking at the difference between the 19A cases, the full jury waiver, and the Rule 8 cases, the real focus of the bench trial waiver is the bright line rule comes from Siumi, which is based on judicial administration of not wanting to waste time after trials of reconstructing whether a waiver was knowingly and intelligently voluntarily made, and also from the statute. And Osborne says that the requirement of a signed written waiver is an important protection provided by the legislature. Here, the legislature has taken a different approach where the statute doesn't touch on the issue of how the waiver should be accomplished, but only touches on that how the 5-juror pool can be accomplished, which is by stipulation. It doesn't actually address the issue of waiver, so there isn't that the legislature hasn't required that extra step of protection here. And comparing it to 19A cases, not only has the legislature required it be in writing, but 218 Section 26A actually requires that the form itself, what it should contain, including a defense counselor's certificate that indicates that the defense counsel has spoken with his client, given him all his rights, that this is a knowing and intelligent voluntary waiver according to defense counsel. So there is actually substance to that waiver because of the form actually contains certain information, and it'd actually be an important piece of evidence if there's ever a post-conviction challenge to the waiver. Here, if there's just a one-sentence handwritten thing signed by the judge, I don't know how much it would provide, and I think the judge put us in the best position by conducting a full colloquy. And while there's no dispute that the rule is what it is and it should be followed, we're not saying that the rule shouldn't be followed, we're just asking what the remedy should be in this situation where the rule isn't followed. And this is a particularly harsh remedy the defense counsel is asking for, where there's undisputably no prejudice to the defendant. He knowingly, intelligently, and voluntarily waived this right after a full colloquy, after affirming that he had sufficient time to discuss it with defense counsel. Defense counsel affirmed the same thing, and for those reasons, the motion for...
Go ahead.
No, please.
Do you think that the statute 234A, Section 68, has any application here?
Section 4, Section, sorry, 26.
One that says that you can do it by stipulation?
Yes, I think that's the section that controls of how, the fact that you can reduce a jury from 6 to 5 or 12 to 11, and that it is done by stipulation.
So it
between the
does
parties.
apply?
Correct, it does apply, but I would argue that,
And he says he did not stipulate. What do you say to that?
I think he absolutely did stipulate. He stood in front of the judge and said, I want to go forward with 5 jurors, and I know my rights, and I'm 100% agreeing to this. I think the real argument is that the Commonwealth didn't stipulate. I think there's certainly, the Commonwealth never objected and certainly was happy to go forward with the trial. And I also point out, I'm not sure the Commonwealth, after jeopardy attaches and the defendant indicates he wants to go forward with 5 jurors, could object and force a mistrial, because I'm not sure that would be a manifest necessity under Commonwealth versus Nickel. And so I don't think the Commonwealth is actually in a position to object after jeopardy attaches, because you would run into a double jeopardy issue.
If the rule's been violated, and obviously the defendant's looking for a new trial, should there be some sort of consequences for the violation of the rule, or should we just say, well, don't worry about it? You said
in terms of
something
getting a
about a
second-
remedy. You said something about a remedy, and what should the remedy be? Should there be some consequences to the fact that Rule 19B's been violated?
Well, the remedy I think should be the same under Rule 8, where we have to make sure there's sufficient other evidence on the record, not a post-trial expansion of the record, but on the record from the trial to make sure that the waiver was knowingly, intelligently, and voluntarily made. And I think that is certainly the case here. The colloquy was lengthy. It certainly communicated all the defendant's rights. And he went over the defendant's mental health issues and ensured that that wasn't affecting his ability to understand that issue and make his rights. And I'd also point out there's a difference between 1980 and 19B, going from a jury trial to a bench trial and just reducing it by 1 juror. In the reduction issue, you still have a jury of the defendant's peers selected by the jury, using all his preemptory challenges and his for-cause challenges. The defendant's actually in a strategic position where he's able to evaluate the case, who showed up as witnesses, the evidence that's come in, and decide whether he wants to continue to go forward or have a mistrial and start another day. So I don't think So I think there is reason to believe that the legislature, who clearly knows how to indicate when they want a written waiver, decided not to have a written waiver in this case because it's a different sort of waiver. It's not fundamentally altering the trial where you're going from a jury trial to a bench trial, but you're going from a jury of 6 to 5 that was still selected by the defendant. So you're still having a jury trial, just one below what is constitutionally mandated, but it's still the defendant's choice.
Do our reporter's notes speak to the reason why 19B requires a written waiver? Does it say
That's
anything?
an interesting point, Your Honor. I think the reporter's notes actually indicate that 19B is actually out of date, because you see subdivision B, this subdivision is in accord with current Massachusetts practice as stated in General Laws, Chapter 234, Section 26A, which is, of course, the repealed statute, which Gallo recognized was the one that required a written waiver. So I think it says it reflects a law that's no longer in
So
existence.
it was a reflection, so it's a relic of what the statute used to be.
Correct. So that rule came out in 1978, and the statute was repealed the same day in anticipation of the rule. So I think that's when the rules were being made, they thought that's what the law was. The law changed the day the rules came out. So it doesn't actually reflect current practice.
The defendant brought up a couple of times, so I can't resist asking you. They brought up a couple of times that 10 years ago you were, not you specifically, but you, the Commonwealth, were up there arguing precisely the opposite position in Commonwealth versus Derry.
Yeah, that's not an argument I personally would have made. But someone did make that 10 years ago, and I think this court correctly decided that protection of a written waiver is for the benefit of the defendant. Here, I think, in arguing that there was no stipulation, I think the defendant's doing the same, no stipulation because the Commonwealth didn't agree to it, is kind of doing the same thing the Commonwealth is doing in Derry, and asking for a reversal because the Commonwealth didn't make an explicit stipulation. And I think they're kind of trying to make that same Derry argument in reverse. But here, I think it was clearly a long colloquy. The waiver was knowing, intelligent, and voluntarily made, and that, similar to Rule 8, another important Sixth Amendment right, if there's sufficient evidence that the waiver was good, automatic reversal shouldn't be required, where there's no bright-line statutory rule that a written waiver is required.
And going back to the origins of Rule 19, when Rule 19 was enacted, had we constitutionally declared that you need not only the waiver in writing, but also a colloquy to establish that it was knowingly and intelligently given?
Well, this court has never found that the form of the waiver is constitutionally mandated. The written waiver is required by legislature.
Right.
And the
No, my
colloquy is required by-
question is, we at some point declared that the written waiver is not constitutionally sufficient, that you'd have to do the colloquy that was done.
Oh, it was not that it was constitutionally sufficient. It was SJC was a rule of judicial administration to make sure that to protect against post-conviction challenges. And so SJC, is from 1979, so it was around the same time the rules actually came out. If there are no further questions, I'll rest in my brief. Thank you.
Thank you.